You and the students have just received the problem. You spent at least a weekend reviewing it and considering the importance of the evidence. Now it's time to go over it in class and assign roles. Welcome to PA Voter Information Network. This is Larry DeMarco, your host. Are you anxious about this upcoming election season? Well, I have a cure. Just click the subscription button on my YouTube channel and all your opponents are guaranteed bad luck. This is episode 9 of the PA Mock Trial Information Series. Now, the students were supposed to go over the problem and you prepared them on how to go over it efficiently. It's my recommendation that for attorney advisors, contact the school before the next class to ensure that a substantial majority of the students read the problem before you go to the next class. These are high school students, not adults yet, and it's a volunteer, extracurricular, academic activity, not sports. Reviewing the problem is extremely time-consuming, and if there wasn't a lot of time to do it, you want to make sure that everyone completed this assignment before you go to class, or you're risking wasting your time. So check before clearing your busy schedule and losing the travel time. Take it from me, who learned the hard way. So you gave the students instructions on how to read the problem, what questions to ask themselves as they read through the problem, and what questions to consider afterwards. So, during class, discuss it with them as a group. Go through the entire 6 witnesses, stipulations, and exhibits. For each witness, ask the students, what's the relevant background, noting what facts that you want to leave out because it's just a waste of time and it's a time trial. Then go to the significant critical evidence and discuss what evidence is favorable to the plaintiff, prosecution, and what is favorable to the defendant. As you go through the evidence, bring up issues of admissibility and evidence. What evidence will the defendant want to keep out because it's inadmissible, and what rules of evidence apply? They don't need to know how the judge will rule on each item. Just note that there's an issue to be argued, and then you can go and revisit it later. The next things they should focus on are the stipulations. As you go down the list, the students should circle which ones that they think that they will need as a team and which ones they choose not to use. Same with exhibits, which ones are important and which are just a waste of valuable time. Then, which witness is the most important to the plaintiff and prosecution, and then the least. Which witness is the most important to the defense, and the least. And this can complete any preparation before getting to the actual prep. Next item of preparation, opening statements. Depending on how much time you have and how often your group meets, etc., the whole group should prepare an opening. And then, of course, for the next class, give the openings in class and critique by the entire class. Don't critique the students yourself. Ask the class to be their own critics, and always start with what they liked first, what was good, and then ask what can be improved, what can be added for a more effective opening. At the end of openings, you give out roles. Roles should be given as A, B, and C, or 1, 2, and 3. For the first, second, and third witness for the plaintiff and the defense. Please note that every problem is written so that the witness for the plaintiff and prosecution and defense are paired with one another concerning the facts and the issues. So if a student takes the first witness for the plaintiff and the prosecution, he or she should also take for the defense and so forth. Please also note that all the witnesses are gender neutral, so you can have a man or a woman for any witness assigned. In addition to giving each student a number and a letter, A, B, and C, or 1, 2, and 3, which implies to a role, and that role is going to apply to both sides, you should also specify witness or prosecution. In giving that out, you should emphasize to all the students that both witnesses and attorneys are equally challenging. Whereas attorneys are the only roles that are able to give speeches, the witnesses have greater control in the competition because they are able to answer questions rather than just phrase the question asked. So for lawyers, you can also give out a role, opening and closing, but the witnesses will not be able to get an opening and closing speech. In addition to attorneys and witnesses, you should also give the students more than one role, a primary role and an alternate role. You will likely experience attrition throughout the season and absences for not only competitions but also practices. Now, you don't want to be caught without someone and have a void to fill a role. All roles should be memorized. Witness roles must be memorized come competition times. Technically, attorneys can use notes, but they will be penalized brutally for it. When practicing direct and cross for the very first time, the students should write the questions out in advance and provide them to the teacher, attorney, advisor first. Really, they should write their speeches out first as well. For direct examination, the questions should always be provided to the witnesses so they can prepare their answers. Remember, the official evidence is not what appears in the statements that are written in the problem. The evidence is what the witness actually says. The opening should be provided to the entire team also, so everyone agrees with the case strategy. The closing argument can only argue facts which were presented at trial, so the team really should coordinate what evidence they plan to present, because you can't prepare a closing argument arguing evidence which the witnesses don't plan to present in the first place. The more class time the team has to practice, the more the students will learn, the better they will show in the competition. Leave time to explain experts, laying foundation for exhibits, and proper courtroom demeanor. It should be practiced as well. After all the speeches, witnesses, and other matters are practiced and learned, if you don't have enough students for 2 teams, I strongly recommend that you schedule a scrimmage with another school and team before the competitions. Preferably, leave yourself with an opportunity to practice each side, plaintiff, prosecution, and defense, because you have to do each in the competition. You can contact your district coordinator for the names and numbers of other high schools and coaches, and most of whom will be willing to practice with fresh faces, time permitting. So you really want to do this in advance. This instructional video series was meant to get teachers and coaches over that initial hump, to conquer a fear of the unknown, if any, and to get the team started. If you don't have a program in your school, I hope you'll start one. This is a worthwhile program. To me, more valuable than high school football. Putting energy, focus, and commitment into this tournament is like having another free year or free semester of civics education for all the student participants. I hope you liked this video series. If you did, please subscribe to PA Voter Information Network. Forward this link to an attorney friend who might want to coach, or a high school student, high school teacher, or high school administrator who could benefit from becoming involved with a mock trial team. Don't forget to click the like button and leave a comment. I would love to have your feedback. Signing off. Tune in next time. Bye for now.